Well, good morning, everyone, or good afternoon, I should say, and welcome to the Employer Handbook Zoom Happy Hour. My name is Eric Meyer. I am an employment attorney at Pearson Ferdinand, LLP, and also the proprietor, publisher, author, and grand poobah of the employerhandbook.com. Joining me today is Mark Mathis, one of my go-to employee benefits attorneys at Pearson Ferdinand. He really needs no introduction, but I'll let him talk himself up. Mark, how are things going today? Tell everyone a little bit about yourself.
Doing very well. Just dealing with day in and day out challenges associated with sponsors who have, their benefit offerings from 401k plans to group medical to a bonus arrangement for another partner this morning. Most everything is driven by the federal tax code, but we're in ERISA. So you may think of me as an ERISA attorney. But I cover the full waterfront, from qualified plans to welfare plans to equity compensation, all of the different aspects of a rounded out benefits practice. So
thanks for being here, Mark. We really appreciate it. So, folks, we do have a big lineup and an aggressive lineup to try and cover within an hour. But again, if you do have questions, please pose them in the chat. I believe the closed captioning should be turned on. If anyone's having issues with that, let me know. But feel free to utilize closed captioning if you need it. Also, like I said, if the recording goes as planned, doing it a little bit differently now, but doing it to the cloud. But hopefully this records properly, and if it does, it will be posted to YouTube. I will share the link on LinkedIn and in Monday's blog post to that. Also, need to give a disclaimer. Mark and I are lawyers, but we're not your lawyers. I don't think we're your lawyers. Maybe there's some clients here. But for the purposes of the next hour, we're not your lawyers. So we're not creating any sort of attorney-client privilege by answering any questions, and we're not providing any specific legal advice. If you have questions, specific legal questions that relate to your business, don't get it from a free Zoom. You don't want legal advice there. Call up your lawyers and get what you pay for, right? Talk to your lawyers and have them give you advice. Okay, now that we've dispensed with the introduction, let's talk a little bit about, well, what's going on. I'll be quick because I think most of you want to hear more from Mark. You probably had it up to here with lawyers talking to you about the changes to the Department of Labor independent contractor rules, but let me give you a brief overview, okay? So, brief overview of the Fair Labor Standards Act. I could probably do several hours on this, but I'll try and keep it to an elevator speech. Fair Labor Standards Act, for those who may not know, is the federal law that governs the payment of wages in the workplace. Essentially, it provides that employees must be paid at least minimum wage. And for non-exempt employees who must be paid at least minimum wage, if they work more than 40 hours in a work week, they need to be paid overtime, time and a half. The Fair Labor Standards Act covers, notice I've been saying employees. It does not cover independent contractors. So if you are an independent contractor, as we'll talk about today, you don't need to be paid minimum wage. You don't need to be paid overtime. Frankly, you can be paid anyway, the two sides agree to pay. We'll talk about, as we get on today, who is an employee and who is an independent contractor, at least under the Department of Labor. So a little bit more brief background. We're talking today, at least in part, about the Department of Labor's final rule on independent contractor classification. That final rule was announced on January 9th after a comment period, 2024. It is set to take effect on March 11th. So Monday is when the Department of Labor independent contractor rule takes effect. Now, I should note that there are several lawsuits pending. So to block the rule, so it is possible, although I wouldn't think it's probable, but it is possible that some federal judge could enter a nationwide injunction before Monday or shortly after the rule takes effect. That is possible. I also want to put out there that even if this rule does take effect on Monday, we are in the final year of a presidential administration. If there is a change in the Oval Office, and I'm not trying to make this political, but I'm pointing out the obvious, if there is a change from Democrat to Republican in the Oval Office, I would expect that this final rule will be rescinded next year. But we're not in 2025. We're in 2024, and you're here to hear about the final rule. So why is the Department of Labor doing this? Well, from the Department of Labor standpoint, the previous rule that was in effect didn't align with how courts have interpreted the Fair Labor Standards Act, specifically under the final rule that was proposed earlier during the Trump administration. Its designation of two core factors, control and the opportunity for profit or loss, which are given greater predetermined weight in the analysis, didn't comport with how courts were looking at whether someone's an independent contractor or an employee, at least under the Fair Labor Standards Act. The current Department of Labor was also critical of how much consideration of a worker's investments and initiative only as part of an opportunity for profit or loss factor. Didn't like that. Was also critical of the prior rules prohibition against considering whether the work performed is central or important to the potential employer's business. So put simply, they thought, the current DOL thought that the prior final rule was just too narrow. Okay. And the Department of Labor thinks that the old rule would confuse businesses too much because it was a departure from earlier case law. Personally agree with that, but who am I? I'm just a lawyer blogger who's talking for the next hour or so. But I don't wear a black robe, and I don't bang a gavel, and I don't work for the Department of Labor. Anyway, that's a little bit of background on the Department of Labor's rules. We'll get into more of the nitty-gritty of the final rule in a little bit, but I want to turn it over to Mark to give a little background on IRS considerations. What is the Internal Revenue, and how do they look at independent contractors?
Yeah, it's life is complex and it's unavoidable. And what we've essentially got here is we've got a separate set of rules that are applicable pursuant to the Internal Revenue Service. And so for employee benefits and executive compensation, where you see this determination of whether or not somebody is an independent contractor or an employee play out, is most likely going to be in a plan that's governed by ERISA. And ERISA broadly preempts state law, and the Internal Revenue Service has provided a definition of what it means to be an employee. It's a facts and circumstances analysis. It came out in a revenue ruling in 1987, and it was basically a regurgitation of what the current law was then, based upon case law, and then based upon the IRS's regulations and ruling positions and everything. And it's what we refer to as the 20-factor test. It's looking primarily at control. And so when we use in, say, for example, a 401k plan, and we don't define employee, or we define him to be, a common law employee, that's generally a reference to the Internal Revenue Service's definition. And so that differs from what you have to rise to be an employee for purposes of DOL's rules. And then you have potentially, or you do have another standard out there for states. And so when you use that, an employee, lowercase e, to become an eligible employee in a 401k plan, for example, we go back to that common law definition. And in the mid-'80s, Microsoft had a really a bad set of facts. It had an employee stock purchase plan. And those are equity compensation. They are tax preferred. And you can go in and you can buy stock of your employer at a discount. And then you have kind of a savings feature. You go in and they'll take money out of your paycheck and then go to turn around and buy stocks, every so often or whatnot. Well, there were two people sitting beside each other at Microsoft. One was an independent contractor and had been so for years. And the person sitting next to him was a common law employee. And, Microsoft stock is going through, it's splitting, it's, rising in its value. An independent contractor's like, gosh, this guy's doing the same job I am. We've been sitting next to each other for 10 years and he's a millionaire and I'm barely scraping by. Well, there was a lawsuit that got filed. And basically Microsoft had to settle it. And it was settled for, in today's terms, $173 million. So this can be a substantial determination in the employee benefits world. We reacted to this by inoculating plans against it, but that's kind of backfired on us with the Affordable Care Act, and Eric and I will get into that a little bit later. But the IRS has basically the 20-factor test, and in 2001, they came out with a publication where they kind of boiled it down to three primary, it's in 2021. It's publication 5520. You can just put in IRS publication 5520 and Google it and pull it up. It's a one-pager basically. And it gives three different characteristics and then examples on what it means for under the IRS's view to be an employee versus an independent contractor. So really what the service did is, in a kind of unusual way, by doing it in a publication, really added gloss to the revenue ruling. So actually you've got two different statements of the rule out there. But it's important to note that they're facts and circumstances. And that's really the case, with the DOL's rule as well as I read it. And that means we don't have a bright line test unless it's just a slam dunk. And so as people are going back and revisiting the worker classification, the message that we've been kind of drumming on, or I've been drumming on internally as an employee benefits attorney, is going in and talking to our employment attorneys and saying, hey, listen, if we're going to do this analysis, you need to bring in the HR people over benefits. And they need to take a fresh look at this too, because their plan may not have, the protections that we would ordinarily expect to see. And there could be some odd outcomes there. And so that's kind of what's going on from an IRS perspective. It gets a little bit more complicated because they have statutory employees and statutory non-employees. So it gets a little bit deeper. Insurance agents, real estate, somebody who sells real estate is an independent contractor. They have safe harbors for certain roles. But that would override the facts and circumstances test that I talked about. So, nothing's ever simple. And,
right.
And so in benefits world, that's doubly the case.
Right. And as many folks in the audience know, the Fair Labor Standards Act is anything but simple for a statute that is like 80 something years old. There are so many little minefields and areas on which we can get tripped up, and it's anything but clear, notwithstanding what the Department of Labor is attempting to do with the change to the department to its independent contractor rule. So I want to highlight real quickly a couple of the key differences between the 2021 independent contractor rule and the one that's going to take effect on Monday. So the differences include a return to a totality of the circumstances economic reality test. What does that mean in plain English? Basically, there are 6 factors, well, 6-ish, 7 possibly, that the Department of Labor is rolling out as part of the new rule, and no one of them is dispositive over the others, right? You just throw it all in a pot, stir it up, and you see what it looks like, taking each of the factors into account. It'll consider 6 or kind of 6+ factors instead of 5, as was in the 2021 rule. There's additional analysis of the control factor, including a detailed discussion of how scheduling and supervision and price setting and the ability to work for others should be considered when analyzing the nature and degree of control over a worker, control being one of the factors in both the old test and the new test. The new 2024 rule will weigh whether the work is integral to the employer's business rather than whether it is exclusively part of an integrated unit of production. And it omits a provision from the 2021 independent contractor rule, which minimized the relevance of an employer's reserved but unexercised rights to control a worker. So under the new rule, if an employer has these rights but doesn't exercise them to exercise control over the worker, then that would weigh in favor of an employer-employee relationship, even if that control isn't the employer never or the business never exercises it. So real quickly, let me go through, I keep saying 6 or kind of 7 factors in the new test. Let me summarize them real briefly. And if anyone has any questions, throw them up in the chat. We'll get to them now or we'll get to them later. So the first one is the opportunity for profit or loss. And the more opportunity for profit or loss that an individual has, the more likely they are an independent contractor. So some of the considerations here include whether the worker determines or can meaningfully negotiate the charge or pay for the work that they are providing, whether the worker accepts or declines jobs or chooses the order or the time in which the jobs are performed, and whether the worker engages in marketing, advertising, or other efforts to expand their business or secure more work. Also, whether the worker makes decisions to hire others, purchase materials and equipment, or rent space. So these are factors that weigh in favor of an independent contractor relationship. Okay. The second factor is the investment by the worker as compared to the business. So the more worker investment there is, the more likely that individual will be an independent contractor. And here the focus should be on comparing the investments to determine whether the worker is making similar types of investments as the potential company or employer, even if it's on a smaller scale. So it doesn't have to be one-to-one. Clearly, the company is going to be, in most situations, expending more in investments than one individual would. But if there's a ratio, then that would be indicative of an independent contractor relationship. That would all suggest that the worker is operating independently. So what are some examples? Increasing the worker's ability to do different types or more work, investments in that, investments in reducing costs by the worker, or extending market reach. Now, here are some things that don't get factored in as to an investment by the worker. So if the worker is spending money on tools and equipment to perform a specific job, or the cost of the worker's labor, or the cost that the potential employer imposes unilaterally on the worker, it doesn't matter when it comes to evaluating whether there's an investment by the worker in the relationship. The next factor is the degree of permanence of the work relationship. The shorter it is, the more likely it's an independent contractor relationship. The more defined it is, like it could be a series of short relationships and still be independent contractor. But when you leave it open-ended, and I've had this situation where people come to me and say, hey, Eric, we want to, could you prepare an independent contractor agreement or consulting agreement? And I say, okay, well, how long's the relationship going to be? And they're like, it'll end when it ends. And I think to myself, well, that's when I send one of those CYA emails back to the client saying, this may not be the relationship that you're committing to paper. It may say at the top, independent contractor or consulting agreement, but you may be setting up an employment relationship without realizing it. The next one is control, including reserved control. So the less control that the business has over the worker, the more likely the individual is to be considered an independent contractor through the lens of the Department of Labor. So, for example, if the potential employer sets the worker's schedule or supervises the performance of work by the worker, including through electronic means, or explicitly limits the worker's ability to work for others, like you're going to work for us and you're not going to be able to work for anyone else, that starts to feel like an employer-employee relationship. All right, you with me so far? Got a couple more factors. Whether the work that the individual is performing is integral to the company's business. If it's not integral, or it's less integral, then it's more likely to be an independent contractor relationship. And the focus is on whether the function that the individual performs is an integral part of the business, as opposed to whether the individual themselves is integral to the company business. So it's the function that the person is performing, not who they are themselves. Okay. And then the last defined factor, the sixth, is skill and initiative. And the more skill and initiative that an individual has, that a worker has, the more likely, when you're balancing all the factors together, that factor will tilt towards an independent contractor relationship. The last, I keep saying 6 or 7, the seventh factor is what the Department of Labor calls additional factors. What are those additional factors? We'll see. I think that's more leaning on like how have courts interpreted the relationship in the past, but that is the test right there. And I should say this before I turn it back over to Mark to explain the nuts and bolts of the IRS independent contractor test. Is I mentioned there are a couple lawsuits pending. I mentioned there could be a change in administration. There's also a Supreme Court case pending that talks about the deference that a court is required to give to an administrative agency's interpretation of the law. And it has to do with Chevron deference and other forms of deference. And I'm not going to make this 1-hour Zoom about that, but I just want to highlight that for you, because if the Supreme Court rules that courts need not give much, if any, deference to how administrative agencies interpret federal statutes like the Fair Labor Standards Act, this rule, this 2024 independent contractor rule, which is going to take effect on Monday, may not have any or maybe minimal persuasive value in a courtroom if this ever gets tested. If a person sues claiming they've been misclassified, the DOL rule may not have much, if any, value in weighing whether someone is an employee or an independent contractor. Anyway, enough from me. Let's go back to Mark and talk a little bit about the nuts and bolts of the IRS rules.
Yeah, I put Eric was kind enough to give you a link to the note to the publication 5520. I went on ahead and gave you a link to the revenue ruling. I hope that everybody on this call hasn't had the misfortune of having to go in and read revenue rulings. But it is instructive to sit there and to look at what the service considers to be the restatement of what the law was in 1987, which is, this is all still good law. But A7-41 looked at 20 different factors. There's quite a bit of overlap with DOL's rule, but it's not, really on all fours in every respect. So they looked at the level of instruction. And this is key, and it's central to the IRS's position that there has to be control. What is the level of instruction that the employer or the service recipient has over the service provider? The more control about that comes down to that, then more likely they are to be an employee. Training also plays into this. Does the service recipient provide that the independent contractor or service provider go through any specific training there at the company? Does he or she mirror an experienced employer? Or, is it the case that the person is out there getting their own training on their own time and at their own expense? The degree of business integration. How integral are the services that are being provided, or what is being provided by the service provider to the service recipient? And is it staining and repairing a fence, or is it an integral part of the business that the business would be dependent upon? They looked at the continuity of the relationship. So, is that relationship short-lived? Is it long-term? Is it intermittent in nature? And keeping in mind, a seasonal employee will still be a seasonal employee, so you'll factor that out of the test there. Here's a really interesting one, and I hadn't thought about this much, and it's called flexibility of schedule. Am I controlling my schedule as the worker, or is the employer controlling my schedule? If I'm working at the pizzeria, they're going to have a schedule that's posted. It may be online, and I'll know that I'm supposed to go in at 2:30, and I don't get done until 8:30 or close or whatever. Or is it the case that I can go and provide the services that I have contracted to provide, at any time based upon what the business's needs are? That same restaurant's not going to accept deliveries from 11 till 2. And so that's pretty common. But that really wouldn't control if I wanted to show up before 11 or show up and after 2 to perform the work during a slower period of the day. Demands for full-time work. So here you're looking at the employer's control, again, over the amount of time that's being worked. The need for on-site services. This next one is another interesting one. Sequence of work. Does the employer have a specific sequence that it wants all of these services to be provided so that it integrates with the business's broader plan? Or is this just a situation where the services that are being provided are ancillary and unrelated to what the ultimate business is, such as repairing and painting a fence, unless you're in the repair and paint a fence business? Requirements for reports, method of payment is interesting. Would I be paid on an hourly basis? Would I be paid on a weekly basis? How does that work? Or do I go in and do I negotiate a one-off price for providing the entirety of the services for a particular scope in the work that's to be performed? And that kind of segues into, am I at risk economically as a service provider? So let's say I bid on providing the materials and services to do a function, and it turns out that I have to provide, or I have to pay more for the paint that I'm using, or I had to buy more lumber for the fence than I ever expected. Am I going to be economically on the hook for that? So that would be kind of the profit motive that would come back in there and be indicative of the fact that I would be an independent contractor because I'm in this for a business. I'm not in this for a wage, so to speak. Let me get kind of back on track. Repayment of business or travel expenses. It's almost per se an employee status if you get a reimbursement from the company for business or travel expenses. Provision of tools and materials. That's a little bit different from what Eric was talking about. So the service will take into account whether or not the tools or provisions and materials are being provided by the employer or they're being provided by the service provider. Investment in facilities, realization of profit or loss, The ability to work for multiple companies. Some employers want you to dedicate your time to providing services to them. And they don't want you working for other service recipients. So if I have the ability to go work on multiple fences and order them the way I need to order them based upon whatever kind of commitment I've made to you, then that would be indicative of the fact that I'm more of an independent contractor as opposed to an employer. My availability to the public, again, that goes to really essentially the same element. Control over my discharge. They can fire me. I'm an at-will employee if I'm not providing the services the way that they think I need to be providing. It's true if I'm doing a sloppy job repairing the fence and my paint is not going on thick enough, then they could probably dismiss me for that. You're looking at the control over discharge and then the right of termination. Now, in May 2021, the IRS really kind of, I think, tried to simplify this by putting out Publication 5520. And it's literally, an image, and it has 3 factors. They want to know if there's behavioral control. Does a business control or have the right to control how the worker does their job? The type of instructions that are given, the degree of the instructions, the evaluation systems, and they're looking at the component of training there too. And so this goes back to some of the factors that we saw in the revenue ruling. So the types of instructions given, I hire a housekeeper, the house cleaning SWAT team is what I refer to them as. And they come in and they're here for 4 hours. I mean, we're cordial. We talk about things that need to be done, but I really don't have control over anything that they're doing while they're here. I'm not providing them with specific instructions. And so I don't have that degree of control or the degree of instruction. How I evaluate them is very different from what the way you would probably evaluate an employee. And I'm certainly not providing them with any training. They know what they're doing. The second factor is financial control. Does the business have the right to control the economic aspects of the worker's job? And factors to consider here would be, a significant investment by the worker or the company. Unreimbursed expenses, as we discussed above. If I've got expenses that are not going to be reimbursed, that are normally reimbursed, that's going to be indicative of the fact that I'm an independent contractor. The opportunity for profit and loss. We talked about that above. Services available to the marketplace in general, and then the method of payment. That goes back to am I going to get a check every 2 weeks and it's going to be based upon the hours that I log or my salary, or, is the amount of work that I'm performing being bid out as a single cost, or maybe it's paid over a period of time, but it's not in relationship to really necessarily the work that's being performed. The third factor here is how does the worker and business see the relationship with each other? What do the written contracts say? Are there employee benefits? Having benefits would be, by definition, dragging somebody into a classification as an employee, because it is called the Employee Retirement Income Security Act. Now, with that said, with equity compensation, you will typically provide stock options or some type of incentive compensation to independent contractors and other service providers as well. And then the permanency of the relationship. Is it intermittent, or is this like the Microsoft case? I had worked there as an independent contractor for 15 years. I came when everybody else came. I, had my vacation time, whatnot, and so on and so forth. And then the last factor there are services provided as a key activity of a business. I mentioned this before, but I'll go and mention it again. There are things called statutory employees. And workers are independent contractors, regardless of what they would be put in for purposes of the IRS's test that we just discussed. And this, a full-time life insurance sales agent whose principal business activity is selling life insurance or annuity contracts, or both, primarily for one life insurance company, not a free agent out there. I'm trying to pick another good one here. An individual who works at home on materials or goods that you supply and that must be returned to you or to a person you name if you also furnish specifications for the work to be done. And so these are really targeting specific services that are out there in the economy. Historically, they've been probably treated as an independent contractor, and they didn't want to go in and upset that relationship. They're also statutory non-employees, and these are really direct sellers, licensed real estate agents, and companion sitters. I'd never realized we had a companion sitter, so I'll treat you and focus a little bit on that. A companion sitter is an individual who furnishes personal attendance, companionship, or household care services to children or individuals who are elderly or disabled. So it's not, your child care person. It would need to be to a child who's elder. The child's not going to be elderly by definition. They're going to be disabled probably. And so, those three categories are definitely statutory non-employers or employees. So they're going to be independent contractors by matter of law, assuming you meet that definition. And so that's probably much more detailed than you ever wanted to know. So I'll turn it back over to Eric before I am accused of being a tax wonk.
That's okay. That's okay. Every company needs a good tax wonk at their disposal, right? That's why they pay you the big bucks, Mark. So let's talk a little bit about what is the net here, at least I'll focus on the Fair Labor Standards Act. Mark will talk a little bit about from a benefits IRS perspective, and then we'll try and overlap, right? Because one of the questions I have is what happens if a company, in light of the new Department of Labor rules, decides we're going to audit and reclassify certain people who were independent contractors and make them employees? Like, okay, that has a defined impact from a wage and hour standpoint, but how does that affect benefits? How does that affect you from a tax standpoint, go back and going forward? So we'll table that for a second. But let me talk a little bit about how the final DOL rule will impact employees and independent contractors. I don't know. I think it's a wait and see approach, right? How much are the courts going to defer to the Department of Labor's interpretation of who is an independent contractor and who isn't? I mean, just because the DOL says so, that doesn't mean that a court of law will say so. If the Department of Labor darkens your door and does a random wage and hour audit, yeah, then it matters. Then it matters because they don't have to defer to anyone else, at least at the initial audit stage. If the Department of Labor determines that someone's been misclassified, they're going to, assuming that this person worked more than 40 hours in a work week and hasn't been paid overtime, then they're going to come after you for that. It's a bit of a moot point if you've missed from a Department of Labor standpoint. This is one of my smaller takeaways, but it's a takeaway nonetheless. If you have people who are misclassified as independent contractors, that is, they should be employees, but they're working less than 40 hours in a work week, they never go over 40 hours, and you're paying them at least what would be minimum wage if you had properly classified them as employees, who cares? As far as I'm concerned, from the Department of Labor standpoint, from a Fair Labor Standards Act standpoint, who cares? Because the Fair Labor Standards Act is about making sure that people get paid minimum wage and overtime. If people aren't working more than 40 hours, they're not entitled to overtime. Okay. Another thing I know for sure is employees cannot agree to opt in to independent contractor status. That's always been the case, right? I have seen contracts, job descriptions that are literally two different pieces of paper, pretty much the same job description, except one at the top says independent contractor and the other one says employee, but it's literally the same job description. Just because one of them says independent contractor at the top doesn't make that person an independent contractor. Just because you develop an independent contractor template, or you find one online, or your lawyer gives you one, you go over it with the lawyer, you have a consulting agreement, whatever, and there's all the language in there that is designed to set up an independent contractor and not an employment relationship. That piece of paper isn't worth much if the reality of the relationship projects an employer-employee relationship. Control, lack of investment, we're talking an unskilled worker, whatever. So the piece of paper that memorializes the agreement, the arrangement, is not at all dispositive. For employers that do misclassify under the Fair Labor Standards Act, and if it is a situation in which someone would be entitled to overtime had they been properly classified as an employee, that is the major implication. You will owe that person back pay. You will owe that person, more likely than not, liquidated damages. If it's a willful violation, the statute of limitations can go all the way back to 3 years. 2 years is the statute of limitations for non-willful violation. But if it's willful, then you go back 3 years to collect wages. If it's one person, maybe it's not the end of the world. But if you have a whole class of individuals who you have misclassified as independent contractors, now all of a sudden you have a collective action. Another thing I want to point out too, the Department of Labor final rule, let's assume it does take effect on Monday. Let's assume, even if it doesn't take effect on Monday, whatever. Don't forget about state law, okay? Because some states, like California, like New Jersey, for example, apply an ABC test. The Department of Labor final 2024 rule does not take into account the ABC test. I'm not going to spend much time on it, but just know it is a more stringent test where you have to, as the business, you have to check off box A, box B, and box C in order to classify someone as an independent contractor. If any one of those tests is not met, it's a 3-part test, then the person is an employee. So under state law, someone could be conceivably an employee. Under federal law, they could be an independent contractor, and you would still owe that person potentially overtime, back wages, liquidated damages, all that kind of stuff. Statutes of limitations vary. For example, in New Jersey, the wage and hour law goes back 6 years. Okay, so be careful where, based on where your company conducts business, especially if you're a multi-state employer, different state rules may supersede the Department of Labor's Fair Labor Standards Act. In terms of kind of some, I realize we're getting into about the last 15 minutes. I want to make sure we take some time here for questions. I'm going to talk a little bit more about best practices and then flip it over to Mark, and then we'll take some questions. Best practices, I already talked about looking, don't forget about state law. I would always say consult a lawyer if you have questions about who's an employee and who's an independent contractor. We're not giving legal advice today. We're certainly not creating any sort of attorney-client relationship. Don't get your advice from us on a Zoom. Don't get your legal advice from the law office of Google and Bing. That's a bad idea. Pay for outside counsel to look and look at your job descriptions, for example. Look at contracts, and then go into the nitty-gritty of what is this relationship that we supposedly have with an independent contractor? Is it truly an independent contractor relationship, or in light of the new rule, or maybe even under the existing rule, have we misclassified? So that could involve doing an audit. with the help of outside counsel to figure that out. There's also, and this is going to come out soon, the Department of Labor is looking at raising the salary level test for an exemption under the Fair Labor Standards Act. So if you are paying an independent contractor not enough money in weekly, what would otherwise be weekly salary, to qualify as for an exemption, and that person has been misclassified, they don't hit the threshold, right? Then that person is going to be considered non-exempt if they've been misclassified. If you are paying an independent contractor on a flat fee basis or a set amount per month, right? There's no salary, it's just a flat fee, and that person has been misclassified, or maybe you're paying them by the hour. Probably shouldn't be doing that, but if you are, and they've been misclassified, then that individual will not qualify for an exemption, generally under the Fair Labor Standards Act. So if they've been misclassified and they've worked more than 40 hours in a work week, you're going to owe them overtime. All right. Mark, before we get over to some questions, do you have any best practices from an IRS or ERISA standpoint that you want to share with the audience?
Yeah, I mean, you know, after the Microsoft case, we went in and put in provisions and plans. And essentially they say, you know, regardless of what we've designated this person's status to be, and regardless of whether or not a court or an agency or some type of settlement agreement provides otherwise, a person who's classified as an independent contractor, and I've used, you know, on the non-participating payroll, you know, as a business decision made by the business, they're not eligible to participate in the plan. And so that's kind of one of the first starting points for benefits, is to go back and look at the way in which a 401k plan or a group medical plan or any other type of an arrangement governed by ERISA or an employee stock purchase plan, how it defines employee, and you will kind of see it as eligible employee there. The key, going back to your HR practices over benefits, is, you know, what do you have in terms of the centers of gravity for independent contractors? Do we have large workforces out there providing services who are being treated as independent contractors? The more people you have, the more important it's going to become, because the higher the dollars are going to get. Now, from the perspective of, if we don't have that language and we improperly exclude someone from a 401k plan because we have said they're an independent contractor and they're in fact not, we have a specific correction program under the IRS. It's called Employee Plans Compliance Resolution System. It's a revenue procedure that's about 200 and something pages long, and it provides just reams of information about ways we can go in and make corrections. And so what the IRS did in the mid to late 90s is they came out with this program because, you know, the downside of, you know, not letting somebody participate when they're supposed to participate is, in a qualified plan setting, it blows your qualification. That's a nuclear option. The IRS did not really want that working, so they wanted to incentivize people to find these problems and correct them themselves. And so I routinely work with clients on all kinds of corrections, not only from the IRS's perspective, but we have correction programs under the DOL as well. And, you know, the big thing that we say is, don't panic, we can fix almost anything. It might not be cheap and it might not be the most pleasant experience, but at least we can get to a resolution. You know, so, you know, that's where you start. The welfare plan is going to be a little bit dicier because it doesn't have typically a formal legal plan document. What you will typically get is let's just say you have dental from MetLife. I'm familiar with that because I was looking actually at vision benefits from MetLife for my son, who needs to go to the eye doctor this weekend. And it's a slick, 2-pager. It comes in PDF form. It says what the benefits are. It's basically produced by the insurance company. It doesn't have all the necessary elements to really make a determination of whether or not somebody is eligible to participate based upon whether or not they're an employee or an eligible employee. What really should be happening with your welfare benefits is they should have an underlying legal plan document. And that's where we put the guts of what needs to be in these plans to offer us the protections that we need to have in them. I saw one of the questions talking about international employees. In the context of ERISA governed plans, they're almost always excluded. And so you would go in and look at the eligibility provisions in a 401k plan, and they would say not on the employer's U.S. payroll, or they're a non-resident alien, or they'll use different types of language like that. And so what is typically done is they're excluded. With that said, sometimes you can have some accidents. And I'm working with an employer right now, and one of them where employees in Puerto Rico were eligible technically to participate in that employer's plan because it didn't exclude them. And so we're having to do a correction for that. And so, that stuff is all going on. I do want to mention, before I turn this back over to the Q&A, that the Affordable Care Act really threw a wrench in this. We don't care what everybody else says. If you are actually determined by a court or an administrative agency or anything to be an employee, you're not eligible to participate in the plan. That breaks down big time under the Affordable Care Act, because we have the pay or play rules, we have notice requirements. And if you really go back and think about it, even if you take it outside of group medical, you're going to be typically in insured benefits. So LTD, dental, vision, accidental death and dismemberment, life insurance, all of those things are insured products. If the company is not paying a premium, the insurer is not going to pay the benefit. There's a very easy way for you to become self-insured by providing benefits to someone and not having an insurance policy out there to fund that benefit. If they were to sue under ERISA and prevail, that's going to come out of the company's general assets. And so these liabilities can be really big, and they can get scaled up fairly quickly if you have a lot of independent contractors. And so, that's why I've been out there kind of beating on the drum, since everybody's paying attention to their independent contractor population due to this rule change. Go in and get your HR people that are over benefits to kind of think about what their practices are too, because they could have misclassified workers.
All right, we got a few minutes left for Q&A. Thank you, Mark. Let's see if I can get through some of these. And before I do that, Mark, there's a comment near the end of the chat about a link to 1987-51 or 1987-41. Is that something that you can link to the chat if possible while you do that?
Yeah, I think I tried to link to it and I got some bad language in there.
Okay.
I'll give this another shot.
Perfect.
For the challenged.
That's okay. Someone has asked, would sending an independent contractor for a background check jeopardize your independent contractor status? I don't believe so. No. There may be certain regulated industries where anyone who steps foot in the office, such as a school, or perhaps I'm thinking a prison or somewhere, security wise, would need to be background checked, whether they are an employer or independent contractor. So sending them for a background check should not factor into the independent contractor employee analysis. Someone asks, if you use a temping agency or temp firm, do you protect yourself from misclassification? That's a hard no. That's a hard no. My practice personally does not involve a ton of work with staffing companies, but it does from time to time. But I can tell you that the staffing company is not a firewall that will protect you from misclassification, right? It'll still come down to, is the individual being placed with the business, the employer, presumptive employer, does that person satisfy the 6 or 7 factor Department of Labor test? And generally speaking, temps that are placed with the company are lower skilled, which are, you're trying to fulfill particular roles, and they're doing work that is integral to the business. They don't have much ability to negotiate their terms and conditions of employment, their wages, anything like that. So I would suspect that in most situations where you have a temporary employee who's being placed with a business, that individual is going to be an employee. But then again, these situations are all fact and circumstance specific. So there is no one broad brush rule that would apply across the board. Let's see. There was another question I thought, any insight or guidance for independent contractors in the IT sector who are engaged through an IT staffing agency? I think the rule, the same analysis would apply. I could make an argument that IT is a big part of what any employer does, at least to be able to conduct business. It is integral to their operations. It may not be what the company does for what the company is established to do, but most every company has an IT backbone. So putting someone into IT, I think there's a pretty good argument, especially when they are being supervised, when they're not being provided, or when they are being provided by the company with the tools and equipment to do their job. When other independent contractor factors fail under the 6-part test, I think those individuals would be considered employees as well. Well, I think I've gotten to all the questions. I see someone wants to join the Zoom at 12:58. Awesome. Welcome. So as we wrap up, I want to be mindful of everyone's time. I want to thank everyone for coming out. This was, hopefully you got something out of it. We will wait with bated breath, at least as to the Department of Labor and the Fair Labor Standards Act, to see whether the new rule will take effect on Monday or whether some court is going to enter an injunction or something like that. But if I'm putting my money on it, I think it is going to take effect on Monday. In the final minute, Mark, what do you have going on in your life? What do you want to tell the audience about yourself? A little send off. And thanks for being here today. We really appreciate you.
Yeah, I mean, I'm probably if you ever get on the phone with me with a legal issue, I think you're going to quickly figure out I'm not your normal benefits attorney. I have a personality and like to have some fun when I'm practicing. I've had conversations, I had to get on the phone with actuaries and auditors and accountants all the time, and that's really not the way I envisioned myself when I was growing up. But it's turned into kind of a point of pride that I'm not wearing a pocket protector and can actually crack a decent joke, because I've been in conversations with benefits attorneys before where I can talk to them for an hour and they will not look me in the eye one time. And so I just want you to know that it won't be a boring ride.
Well, wasn't a boring ride today based on the
Probably.
chat we have. Thank you everyone for coming out. We appreciate you. Everyone have a wonderful weekend. The link will be on LinkedIn. I posted some links to connect with us. The link will be on LinkedIn and in the blog on Monday. Thanks again, everyone. Have a great weekend. Bye.
Bye.